We also had Justice Brian Zahra, who Bob confirmed with him earlier today that he'd be here, and he has had some sort of personal situation come up, so he will not be here. I think we've had him here one time before last year. We do, however, have Justice Stephen Markman, who's running for, again, Michigan Supreme Court, and we have Judge Colleen who's running for Oakland County Circuit Clerk. The format that we're going to do is we're going to give these folks 10 minutes or thereabouts, whatever they need to provide a statement to you. And after that, after we're going to let Judge Markman come up first, and then Judge O'Brien second. After that, we'll have our usual question and answer session. And I know that this crowd is particularly well educated and particularly got some tough questions, and we seem to enjoy that. We seem to enjoy having you ask those questions. So without any further ado, I'll ask Justice Stephen Markman to please come forward. Thank you.
Well, thank you very much for the opportunity to be here. It really is an honor to be at the Lapeer Tea Party this evening, to be in particular here at the Maple Grove Church. I did find the reading of the Declaration of Independence to be very inspiring, and I wish that every school child in the state could be exposed to something along those lines, and perhaps around September 17th on Constitution Day, they could be exposed to a reading of that great document. I wonder how many school children in Michigan, in fact, have actually heard the words of those two charter documents of our nation. I've seen the times on your schedule. They're very precise, and I'm very concerned that I not go over those times. I don't know what happens, but I'll try to do my best to work within those times. I've been speaking throughout Michigan as one of your 7 Supreme Court justices since 1999. In countless speeches, I've sought to explain my judicial philosophy and that of the Michigan Supreme Court. And I feel that I've become somewhat repetitive, for my judicial principles do not vary. I don't adjust these principles to the audience, and I commit myself this evening to following the same principles tomorrow that I have followed in all of my yesterdays on the court. In the 30,000 or so cases that I've thus far decided, I have adhered to the best of my ability during my years on the court to a consistent understanding of what the judicial power entails under our federal and state constitutions. And the judicial power is, of course, the only power that judges may exercise under either of these constitutions. So let me briefly summarize, if I can, the essential principles of what I call this rule of law judicial philosophy. And in this regard, I'm speaking for my colleague with whom I've been campaigning over the state, Justice Brian Zahra, who, as you've just heard, cannot make it here this evening. But we've campaigned on the principles that I'm going to outline for you, and at least for the moment, at least as I speak, they're the principles of a 4-3 majority of your Michigan Supreme Court. And I thank you and similar organizations for all that you've done to reinvigorate interest on the part of American citizens in their Constitution and in the judiciary that's responsible for giving meaning to this Constitution. I've taught constitutional law at Little Hillsdale College in southern Michigan for about 20 years, and it really is inspiring to me to see the increased focus that's been given to our Constitution by persons such as those in this room and by organizations such as that reflected this evening in Lapeer County. Let me talk to you about what I view as the rule of law philosophy. And once again, for the moment, it does reflect the 4-3 majority philosophy of the Michigan Supreme Court. First of all, I agree with our first great Chief Justice John Marshall, who said in 1803 that it is the role of the judge only to say what the law is and not what it ought to be. It is the role of your legislature, your county commission, your city council, comprised of your elected and accountable representatives, to say what the law ought to be. If there was any overriding mission of the founders, it was to create a republican form of government in which we, the people, determine important public policies, not kings and not emperors and not even lawyers in black robes. I also agree with James Madison, who said in Federalist number 47, that the accumulation of the separated powers of government in the same hands may justly be pronounced the very definition of tyranny. The judge is the interpreter of the law and not its maker, and it is the judge's responsibility to faithfully interpret the words of a lawmaker, so long as those words do not breach the Constitution. Second, I believe the people are entitled to determine the policies under which they will live, even if I, as a judge, happen to believe that they're mistaken in their judgments, or that better results or better compromises could have been achieved. Judges are not your adult supervisors, and we are not your lawmakers in chief. We don't get to alter or improve your laws with which we disagree, although that is, of course, the great judicial temptation that some judges quickly succumb to. Instead, we the people, that is you and your friends and your relatives and your neighbors, we the people have a right to have their judgments respected, unless what they do clearly runs afoul of the Constitution. Ours is a Constitution that limits judges just as it limits all others in government, and that is the fundamental premise of self-government. Over the course of the past 10 years, when mostly we've had a 4-3 rule of law majority on the Supreme Court, we have sustained your representatives in the legislature and your governors on such things as medical malpractice reform, tort reform, workers' compensation reform, lawsuit reform, criminal justice reform, tax reform, no-fault reform, lawsuit reform, and various other kinds of reform, and almost invariably, those have been sustained by a 4-3 majority of the Supreme Court. The 3 dissenters have looked at the judicial process as simply a process in which those who've lost in the democratic and representative processes of government can get a second shot and try to turn those defeats into victories. And the majority has looked upon the separation of powers and the relationship between the legislative and the judicial branches very, very much differently. Third, I believe the first responsibility of government concerns the protection of citizens from violent criminal predators. This is not one of the top 10 responsibilities of government, along with food stamps and dam projects and public radio, but it is the first responsibility. This is what the very first sentence of our Constitution means when it sets forth government's responsibility to ensure domestic tranquility. The right to be free from violent criminals is the first of our civil rights, and I learned as a federal prosecutor in Detroit many years ago that no society can prosper unless there is this sense of priority. Our criminal justice system is the means by which government carries out its first responsibility of protecting citizens from criminal predators, and judges must treat this obligation as their first responsibility as well. And I've been very proud of the court that I've sat on for the past decade when I recall the statement in the Wall Street Journal, an article in the Wall Street Journal not too long ago, that said that there was perhaps no court in the nation than the Michigan Supreme Court less receptive to creative arguments by which violent criminals can escape responsibility for their actions. Fourth, I believe that our civil and common law is predicated upon traditional principles of personal responsibility and individual accountability. This too is part of what it means to be a rule of law court. I recall reading a handbook prepared by a major lawyers organization advising their newest members on courtroom strategies. On the selection of juries, the handbook offered the following advice to young lawyers, and I quote, "It is helpful to divide the jurors into two groups, one of which are those jurors with a personal responsibility bias. These jurors will tend to espouse traditional family values and often have strong religious beliefs. The only solution, I'm not quite sure what the problem is, but the only solution to this is to identify these jurors and to exclude them from the jury." This attitude, ladies and gentlemen, I believe is destructive of our justice system, and I am emphatically, and our court is emphatically by a 4-3 margin, one that believes that the rule of law is built upon, not threatened by ideas of individual responsibility and personal accountability. Fifth, I believe that the rule of law requires that stability and predictability in judicial decision-making be paramount, and that unnecessary and wasteful litigation is encouraged by our decisions on the court that are vague or in which judicial decisions are plainly inconsistent with what is required by the words and language of the law. And litigation, as I think you all know, poses enormous costs upon society. And we today have significantly less litigation in Michigan than we did a dozen years ago, in significant part because the law has been made more clear and more certain by what one newspaper in Michigan has described as this court's monotonous predictability in asserting that the law means what it says. And finally, I believe in the equal rule of law and consider this to be one of the crowning achievements of our civilization. Therefore, as a judge, as a justice on the court, I am not pro-Republican or pro-Democrat in my decisions. And I'm not pro or anti any group or interest or constituency, except that I am pro-rule of law. There should be no partisan justice, no thumbs on the scales of justice, no judicial constituencies, no doing politics by another name in the courtroom, only equal treatment of the top 100% of the people of Michigan. And I respectfully disagree with our president when he asserts that what is most important in a judge is where his or her sympathies or empathies lie. That is not the rule of law, but it is the rule of judges, and those concepts are very, very much different. And the rule of judges is not our constitutional heritage. And I believe it is our constitutional heritage that has made our nation the freest, the most stable, the most productive, the most creative, the most compassionate nation in the history of the world, a genuinely exceptional nation in which we're all blessed to be citizens. And if Justice Zahra and I are re-elected this year by the people of our state, I promise to bring the very same values and principles that I've outlined this evening to bear in future cases as I've sought to the best of my ability to apply them to the first 30,000 cases that I've decided. And I was honored many years ago as Assistant Attorney General of the United States to have served President Reagan for 4 years as his judge selector. And he once remarked concerning this in a debate over the judiciary, the debate is not whether we will have liberal or conservative courts, for the Constitution is not liberal or conservative. Rather, it is whether we will have government of the people, by the people, and for the people. And if I can live up to the standards that he articulated when I was serving him, I will be very confident that I have lived up to the standards that the people of Michigan and the people in this room have imposed upon me. And I believe that if I can live up to those standards, and if my colleagues can, you will continue to be very, very proud of your Michigan Supreme Court. Thank you very much.
First of all, Justice Markman, thank you. You're right on point. The last period of time has proved why it's so essential, here in Michigan especially, to have rule of law judges, and I commend you for that. Coming up, there's probably going to be something on the order of 6 different ballot proposals that we'll have an opportunity to vote on here in the state of Michigan. And some of them are extremely important, and many of them may eventually filter down to the Michigan Supreme Court through the appellate process. Also, I want to just mention this before we go on. I was advised that I'd like to ask for your prayers for Jane Markey's husband. The situation apparently tonight is very serious, so we have no further exact word, but if you keep that family in your prayers, it would be appreciated. I'd like at this time if Judge Colleen O'Brien would come forward and we could hear from you, and then afterwards we would love it if both of you would come back to the stage and we'll do a question and answer period. And here is Colleen O'Brien, and thank you so much for being here.
Good evening. It's a pleasure to be here tonight. I'm Judge Colleen O'Brien. I'm currently an Oakland County Circuit Court judge, and I am seeking the Republican nomination for the open seat on the Michigan Supreme Court. We have a Michigan Supreme Court justice who's retiring due to age limits, and that's Justice Marilyn Kelly. Marilyn Kelly, I don't know if any of you are familiar with her, but she's a very nice woman, but she has been the most liberal member on the Michigan Supreme Court for a number of years. So this is a great opportunity to add an additional seat to our current conservative majority, which has been referred to by the Wall Street Journal as one of the finest in the nation. And it's of utmost importance that we make sure Justice Markman and Justice Zahra are re-elected. I am seeking the nomination for that open seat, and I would like to run with them as the running mates. The Michigan Supreme Court is so very important. The court is literally the custodian of the laws in our state. The decisions the Supreme Court makes affect not just the people that are arguing before the court, but everyone in our state. And that's why it's of utmost importance that anyone seeking the position of Supreme Court Justice strictly adhere to the rule of law. It's my judicial philosophy that judges must decide cases not based on what they think the law should be, but what the law actually is. Judges have to decide cases in an impartial manner and not allow their personal opinion and viewpoint to impact their decision-making. They have to decide cases based on the laws that's written by our elected representatives. Now, that's not always an easy thing to do. I've been a circuit court judge now for 14 years, and there has been many times over the years when I've had to make a decision that I didn't completely agree with. Maybe I would have preferred to do something different. But as a rule of law judge, I've been disciplined and I've done what the law requires. That's what rule of law judges do. They're not driven by the outcome, but they're driven by the law itself. I don't believe that it's the place of the judiciary to tell our legislators what they meant to say or what they should have said. When judges start to do that, I believe we're starting down a slippery slope towards the erosion of your constitutional rights. If we don't like what the legislators are doing, the answer is to take care of it at the polls, but not to run to the courthouse for judicial legislation. And it's very important that judges follow the rule of law, because when they don't do it, it does have consequences. Judges that base their decisions on their own viewpoint and their own opinion cause our laws to be unstable, because then people are not treated fairly and equally. It even affects our economy, because when judges follow the rule of law, it helps promote consistency and confidence in our system, and that's helped stabilize our economy. Unfortunately, in our state, we do have some judges that don't follow the rule of law. They legislate from the bench. I believe that that's wrong and unconstitutional. Our founding fathers recognized that the concept of the rule of law is the foundation of our country. The rule of law is embodied in our Constitution because our founding fathers wanted to be governed by laws of our own making and not the whims of a king. As so powerfully stated by John Adams, we are a government of laws and not of men. In other words, our actions are guided by established law, as opposed to the arbitrary or discretionary commands of dictators, as we have seen in many other countries. More importantly, the laws apply to everyone, even our government. Our founding fathers wisely provided for a limited government with 3 separate branches. As a judge, that separation of powers means to me that I am not free to intervene in the public policy decisions of the legislative or executive branches of government. I believe that in matters of social and public policy, a judge's role should be limited to determining whether statutes are constitutional or not, and then interpreting that statute if it is constitutional. Our statutes represent the will of the people as expressed through our elected representatives, and that's the way that it should be. Therefore, as a judge, I'm not free to nullify legislation unless it's clearly unconstitutional. In other words, I'm a strong believer in the separation of powers as set forth in our Constitution. I believe in the founding principles of a representative government, and I believe that our laws and our policies should be made by our legislators and not our judges. I just want to tell you a little bit about my background. I'm a lifelong resident of Michigan. I've lived in Rochester Hills for the past 24 years with my husband and our 3 adult children. My daughter's engaged. She'll be getting married this winter to a young man who's in the Navy and currently in his 2nd tour of duty over in Afghanistan. I'm very proud of him. Prior to becoming a judge in 1998, I practiced law for 17 years. And during that time, I had the opportunity to travel around our state and appear in many different courtrooms. I appeared in front of judges who followed the rule of law, and unfortunately, some judges that did not follow the rule of law. I represented clients who became very discouraged at times when they were entitled to a judgment or in their favor, but we were in front of a judge who didn't follow the law. I also, as a lawyer, learned the importance of clear and certain rulings by our Supreme Court, which for many years we did not have, but we have it now. As an attorney, I became very aware of how important it is in a society founded upon the rule of law to have judges that follow the rule of law and what an important role judges play. And that's why I decided to become a judge. I have a 14-year reputation in Oakland County as a conservative rule of law judge. I've had a great opportunity there to have experience presiding over thousands of criminal felony cases, complex civil litigation. I served for a time on our family court. And as a circuit court judge, we also decide appeals from the district and the probate court and numerous administrative agencies. So it's well prepared me for the many serious and complex issues that a Supreme Court justice faces. The circuit court is really where the rubber meets the road. I deal with the litigants, the plaintiffs, the defendants, the victims of crime, the jurors. There really isn't much that I haven't seen as a circuit court judge. I have made it my goal over the years to protect our community, and I think I've done that in 2 different ways. First of all, in cases where I'm dealing with someone that is a threat to society, a danger to society, I have not hesitated to sentence that person to the maximum sentence under the law. However, I've also learned over the years that about 90% of the cases that come before the court, criminal cases, have their criminal behavior rooted in either substance abuse or mental health issues. And therefore, since 2003, in addition to my regular duties, I've presided over the female adult treatment court. We have another judge, Judge Joan Young, that presides over the male treatment court. And that is a program that people can voluntarily come into instead of going to jail or prison. They are in the program for about 18 months. It's only for nonviolent offenders who want to go through intensive counseling, make frequent appearances in court, frequent meetings with their probation officer. And at the end of the program, before they graduate, they have to have a job and have paid off all their cost and restitution. And national and state studies have shown that these programs really do prevent people from reoffending and get them off that continual going through the revolving door of in and out of jail. It helps treat the problem, the root of the problem. So if I am elected to the Supreme Court, I would continue to promote these problem-solving courts. I just want to mention a few of my endorsements. I am very honored to have the endorsement of our Chief Justice, Bob Young, who you all know is a very well-respected conservative rule of law judge. Also we have the endorsement of Justice Mary Beth Kelly, not to be confused with Justice Kelly who's retiring. Justice Mary Beth Kelly was elected in 2010 and has served with distinction since that time as a rule of law judge. Also we have the endorsement of our former Chief Justice Cliff Taylor, former Governor Engler, Congressman Candace Miller, Congressman Dave Camp and Mike Rogers, many grassroots supporters, and Tea Party groups, including Tea Party Patriots of West Oakland. Very proud to have that endorsement. This is a nomination at the convention in September. If nominated in September, I would be on the ballot in November. I'd ask for your support in September at the Republican convention. Thank you very much.
Microphones, you gotta find them, use them. One thing I'll just mention, and I'll just a second for a question and answer period. One thing I'll just mention, the Lapeer Tea Party has in the past endorsed rule of law judges, and we intend to do so again this coming election. And just for the justices know that are here tonight to know where the rubber needs to go. We got out our voters' guides via paper, electronic, and hard copy to probably about 130,000 residents here in Lapeer County, which has about 75,000 residents. So that means we hit a lot of people twice, or some even 3 times. And we did have a pretty good impact. So that's one thing we do look forward to. Mark, do we have the wireless mic tonight?
Yes.
Okay, good. What I'd like to do then is simply start off with the, okay, thank you, Bob. What I'd like to do is start off with the question and answer period, and how we're going to work this. We'll let these good folks here that have been so kind spend some time with us, and we're pleased to have some rule of law judges do that. We'll let them decide who answers what, or if they both answer, what order. I'm not going to get involved in that. I'm going to go down here, be on the right-hand side. I'll be on what we call the leash, because I can't move around because there's just so much cable. And then Liz will have the wireless mic. She's in the back. So we're going to start this right now. If you want to ask a question, if you're towards that side in the back, if you're up here in the front, come see me, and we'll start right now. Tim, you have a question?
First of all, thank you both for coming. I have a great deal of respect for both of you. And I think the Justice Department, especially the Supreme Court, is very important. I guess my question is, everybody who runs for the courts says something similar, okay? How do we know? Can you help us to understand, or how to look to make sure that what you're saying, that I doubt you, but is the truth? I mean, where can we go to find out what these other judges that are also running, who are saying the same thing, their credentials are accurate, I guess is what I'm trying to say. Either way.
Well, as far as my position as a circuit court judge, I do have a reputation. I've been there for 14 years, so if any of you know attorneys in Oakland County that practice there, can obviously speak to them. Also, that's why I mentioned my endorsements, because it's hard. People don't have much information about judges. I would agree with that. And that's why I mentioned my endorsements, because you all know our Chief Justice Bob Young, or most of you do, is a very conservative rule of law judge, and he's very familiar with my opinions, and he is endorsing me. So I think you could find some comfort in that. As a circuit court judge also, We do write many opinions. Those opinions can be found. Some of them are online. I write many opinions, which are the appeals that come up from the probate court and the district court and administrative agencies. As a circuit court judge, I would say about every week I have what we call a motion call. And during that motion call, many issues come before the court. And some of them are called summary dispositions. And those are usually a pretty complicated issue where one party is asking the court to either dismiss the other side's case or render judgment in their favor, taking it away from a jury decision. And I'm more or less saying to the court, the law's in my favor, there's no question what the facts are. I want the court to render a judgment in my favor. So on those cases, most of the judges, and I always have a written opinion, and those things are in the court files and readily available for review.
I don't know that I agree with the premise of the question. Everybody campaigns on what we've been campaigning on tonight. In fact, I've never heard anybody on the other side campaign in support of rule of law principles and constitutional principles along the line that we've articulated tonight in this campaign. I'm quite sure that if our opponents were to be here tonight, you'd not have a very hard time distinguishing between what they said. And I'm pretty confident they wouldn't be invoking the rule of law or describing themselves in that way. But principally, I agree with Judge O'Brien that there are people who have records. As I indicated, I've decided thousands of cases and I've written hundreds of opinions, and those are available to the public. To the extent it's difficult to access those cases, and I understand it is, I mean, we have, I guess what I call intermediating organizations that endorse candidates and that oppose candidates. And I think if you look at their endorsements and if you look at their non-endorsements, those can help give you some clues too. But I'm quite sure that if the people running against, that will be running against us in November were here, you would not be hearing them describing themselves the same way. In fact, if you listen to them carefully, they are focused entirely upon results. They are focused entirely upon how our empathies and sympathies should be communicated. And this is not a subtle part of their campaign, it is the core part of the campaign. And if you hear them critique our opinions and our decisions, the same is true too. They don't criticize our legal analysis, because our legal analysis, I think, is usually pretty compatible with what the words and the language of law say. Rather, they criticize us because we don't always produce the results that they would like to see produced in the legal system. And the way that we determine results in the legal system are by looking to see what your representatives have determined are the proper results in the context of legal disputes and controversies. And that to me is the only way by which we know how properly to interpret the law. And once again, I think you would not hear our opponents, and you never heard judges before the previous 10 years talking about the rule of law in the same way that you've heard judges running for the court speak about that over the course of the past decade.
I just thought of something. I recently saw a brochure from the 3 candidates that have been nominated by the Democratic Party to run for the Supreme Court. And one of them, her slogan is, I want to help families and children. And that's not really the role of the Supreme Court. The Supreme Court's role is to interpret the Constitution and our statutes. So that there really is a big difference between the nominees. They've already had a nominating convention, and the people that are running as conservative justices.
Again, thank you for coming. My question may not be possible to answer. Presuming they get enough signatures on the British petition that's going around, presuming that they're valid and then presuming that it passes. Will that be enough to stop the governor from going around the legislature, from what you understand?
It is perfectly proper for you to ask that question. I don't know that it's perfectly proper for me to answer the question. I apologize for that. But this is obviously a case or a controversy that could come before the court, and our ethical rules and our standards of conduct are pretty clear that we can't discuss those cases that are imminently going to come before the court. All I can say, and I wish I could give you something more to look forward to, is that we will look at the specific controversy that's presented to us at the time. I don't know what it will be. I don't know if it will have to do with the number of petition signatures gathered, or the subject of the petition, or the nature of the font of the position. I just don't know any of that, but we will do everything we can to try to read our laws as carefully as we can, because we do have laws on that subject, and we're not a sea in trying to decide what to do there. We're not there to make up what we think is the right thing to do, whether they should be on the ballot or shouldn't be on the ballot, or should be in the ballot in this form or that form. Your representatives, once again, have made these decisions. And if you don't approve the decisions that they've made in defining how a measure comes to be on the ballot, you either have to modify those or you have to replace the people who make those decisions. But I don't think it's the role of the courts. And I think I'm echoing what my colleagues have said here today. I don't think it's the role of the courts to say, we know how to do it better than you do. The great achievement of our country has been that the people get to make these decisions, and I'm very comfortable and very pleased to be abiding by those decisions, with the caveat that if there's something incompatible with the Constitution in that law, we will also work to protect your Constitution.
One quick point that I wanted to make, and to go on with your question in just a half second, sir, is that the Lapeer Tea Party is neither Republican or Democrat or conservative or Tea Party, and we have endeavored to try to provide all candidates an opportunity. I just want to note that the Democrat Party and these candidates that Justice O'Brien referred to were invited. So just to note, we've had within the local Lapeer County arena, we've had some decent participation with Democrat candidates coming, but even there we've struggled to get them to come. So, but I want to clarify that we're not taking a political party stand. I would love the day that there is a Democrat that runs under the rule of law for our court. So thank you. Go ahead, sir.
It's real nice to see a constitutional lawyer here, the Supreme Court, and the other judge here. I've had a problem. Back a few years ago, I had a friend tell me that the United States government was a corporation, and Michigan was a corporation. So under the Constitution, I figured, well, this can't happen. We can't be incorporated. But if you go into the computer, it was incorporated in 1871. The federal government, Michigan was incorporated in 1872. So what they do is we're running under promulgated rules of corporate law. So the fishery division say, for instance, the people, the boss doesn't even know what they're doing, the lower departments, they're having hearings, they're making laws, they publicize it, and they take us to court. So what I'd like to know is how does these promulgated rules in corporate law and legislation not voted on, like the burn barrel, was a promulgated rule, how does that fit with our Constitution? I could never figure this out. So I'm real glad you two come here tonight.
I'm not quite sure what you mean by the burn barrel. Maybe I'm just not as well informed on that as I should.
DEQ, they come out, the government, Snyder come along They made a promulgated rule that nobody could use a burn barrel anymore. Then Governor Snyder come along and told them that basically, if it didn't get voted on by the legislature, you can't use it. And then DEQ and basically said, oh, let's take off all the waivers. But all the rules are promulgated corporate law rules. There's no saying as legislature voting for it. EPA runs under promulgated rules. So how does that fit into corporation? Or corporation fit?
I have to be honest, I'm a little confused by that question. We, of course, do have very detailed corporate laws in Michigan that apply to corporations in their dealings with individuals and other corporations and government. But we also have a very comprehensive body of law that pertains to governments. I mean, the most obvious distinction is that governments are immune from liability for most misconduct unless they have waived that immunity and indicated they could be sued. So we have a law, for example, that says the government has waived its governmental immunity, which is something that dates back to the Middle Ages and the immunity of monarchs and kings. But we have waived that immunity for many kinds of tort damages and certain other kinds of things. If, for example, there's a badly constructed highway that leads to an accident, that might be something that would allow an individual injured by that to sue the government. But there's a completely distinct body of government law from corporate law, and there may be some areas in which there's similar principles, but I just don't know enough about the burn barrel regulations to be able to respond to them. I'm sorry, maybe my colleague knows more than I do, but...
Come up with a ruling every year. They publicize it. The boss doesn't even know what's going on. George said $100 all the time. They publicize it. We take it to court. After they publicize it for so many days, it becomes law. They take us to court. And the boss doesn't even know about it. Legislature don't know about it. That is complicated rules that our legislature is running on the corporate law. And it is in the corporate law in the state. And the EPA. It's all complicated rules.
All right, we'll move on to our next question.
Well, I'm glad to say that my political involvement goes back when we had a liberal Supreme Court a long time ago. And after the liberals decided that they weren't going to win too many more elections to elect Supreme Court justices, many of them, Brian Dickerson, for instance, of the Free Press, has come out and said that there has to be a better way to elect, select, appoint, what have you, justices of the Supreme Court. As we all know, you can't pull the R lever down and vote for a Supreme Court judge or pull the D lever down and vote for a Supreme Court judge. You have to purposely vote for a Supreme Court judge, and occasionally in the Democratic circles that's not passed. So what they'd like to do is find a different way to get Supreme Court justices. I guess my question to you is, do you think the way we do it now to elect you is a good way, or is there a better?
I know there was recommendations that just came out. A committee studied and made recommendations on whether the way that Supreme Court justices are selected should be changed or not. And I understand that there are valid arguments on both sides. I think that our present system for electing Supreme Court justices is a very good one. Supreme Court justices, as I said earlier, play such a very important role in our state. They have such an effect on everyone. And I think it's the best way to do it is have justices nominated at a party convention so that people do have some idea whether they are voting for a rule of law judge or a more liberal justice. I will say that I do think they raised some valid points in the recommendations that came out recently. There were some recommendations that maybe the age of retirement for judges, which is currently 70, should be raised. I agree with that personally. We've had a lot of judges in my court that have had to retire that were just wonderful judges and had so much institutional knowledge, and it's just been really devastating when they left our court. There's recommendations regarding education, increased education of the voters and ways to do that, and I'm fully in support of that. But I'm really not in support of changing the method of nominating the justices at Party Convention.
I very much like that judges in Michigan, as in most states, are in the democratic process, unlike federal judges. As a result, I get the opportunity and I have the obligation to go around the state and speak with people and share my thoughts, and participate in the judicial debate, and to hear your thoughts and to attempt to the best of my ability to respond to your thoughts. That's something that federal judges don't have to do, and I think it's a good thing for our society that the judicial process is brought more closely to the people. The thing I'm most concerned about, on the other hand, in the system that we have in Michigan, is simply a function of the increasingly large amount of money that's involved in the process. Back as late as the mid-1990s, an incumbent justice might have to spend $50,000, $60,000, $70,000 in the course of his or her re-election campaign. These days, we have to raise $1 million, and there are far more dollars than that spent by outside organizations that both support our candidacies and oppose our candidacies. Now you ask, what's wrong with that? What's wrong with that, or at least what concerns me about that? There's nothing wrong with the idea of money going into the political process, because that's how most people speak, unless they happen to own a newspaper, for example. That's how people communicate their preferences. But the concern that I have is that when you spend such large sums as you have to spend in the process today, it is very difficult for us to decide a case without somebody being able to look at our decision and say, well, you know, that decision seems to us to be responsive to the fact that candidate A got so much money from this lawyer or from that organization, or he was opposed by that lawyer or that organization. In other words, there is almost no decision that we issue in which those people who wish us ill can't look to define that decision as somehow being a function of where we're getting money from and where we're not getting money from. And there's nothing in my judgment over the course of the past 15 years that has more called into question the integrity of the court. Now let me emphasize, I believe that your Michigan Supreme Court over that time has been a hugely honest court with the highest level standards of ethical conduct and integrity. But there's that constant appearance problem there when you have such large sums of money that are going back and forth in the campaign. And if I had my ideal system, there would be something that would be done to try to rectify the appearance of impropriety problem that's been introduced into our judicial system as much as it has, because I don't think it's good for the judiciary that so many people are exposed to arguments, false arguments in my judgment, that judges are responding to where money is coming from and where it's not coming from. I mean, there's nothing in my judgment that over the long term can be so corrosive to our justice system and our judiciary.
Thank you. My question is for Justice Markman. I've always been interested in knowing how the Supreme Court decides to take a case or not to take a case. Can you just talk to that issue a little bit?
That's a very good question. Each month, we get about 200 to 250 cases that are filed from all the 83 counties of Michigan, including more than a few from Lapeer County. And in almost every one of those cases, in fact, in every one of those cases, the party that's lost in the Court of Appeals is seeking to reverse that decision. And in about 99% of all these cases, we are the last stop in the legal system. In the other 1% of the cases, when there's some federal constitutional issue at stake, there is, of course, a final opportunity to bring a case to the United States Supreme Court. But that happens really quite rarely. So the question is, how do we take those 200 to 250 cases and decide which ones we're going to actually hear oral arguments from and have the lawyers come in the courtroom and go back and forth on the cases? It's essentially those cases that we think are most significant for the legal system in Michigan. Those cases in which if we decide something today, it might affect the way that 100 or 200 cases are decided around the state in the next year or two. It's the cases in which the judge from Lapeer County is deciding things differently from the judge in Sanilac or Tuscola County or Kent County. It's the cases in which we need to make clear what the law is in Michigan so we don't have 83 systems of judging in the state of Michigan. So if there's one factor, it would be those cases in which lower court judges are deciding Michigan law differently, and those cases in which our decisions will be felt most strongly around the state in terms of dozens or hundreds of other cases in the near future.
I'm going to try to take a crack at a question that was raised earlier and rephrase it in terms of things like administrative fiat, where our executive branch departments are making their independent decisions of what laws mean, or on the national level, for example, executive orders from the president. What is the role of the courts, let's look particularly at Michigan, in reviewing the authority of the executive branch to make decisions that certainly often appear different than the legislative intent?
The executive branch does have the right to issue certain orders, but it's constitutionally based. So it's my opinion that it's the role of the court to look at those executive orders and determine whether the executive had a constitutional basis to issue that order or not. And I would just like to explain, and Justice Markman touched on this a little bit earlier. As judges, we do have to be somewhat careful on what statements we make. And the reason for that is because if I told you how I felt about a specific subject, and later on that case or an issue similar to that came before the court, if I'm elected to the Supreme Court, I might have to disqualify myself. If one of the parties ever found out down the road that I had given my opinion on a certain subject or maybe hinted at how I would rule on something, that could be a basis for disqualification in the future. But yes, my concern with that type of issue would be to look at the Constitution and see if that was allowed or not, and look at it in that way. Thank you.
As I've told my class at Hillsdale College for many years, one of the great constitutional transformations over the course of the past half century has probably been in the area of what is generally called administrative law. As you know, the very first sentence of the very first article of our United States Constitution says that all legislative power belongs to the Congress. But over that past century, we have introduced a delegation doctrine that essentially allows the Congress to delegate what appears to some people to be essentially the equivalent of legislative authority to the administrative agencies of the executive branch. This was originally justified on the basis that simply the complexity of these kinds of administrative rules and regulations required that they be done by these agencies as opposed to members of Congress, members of the legislature, who just never would have the time or the expertise to do these rules and regulations on their own. But nonetheless, it is one of the great constitutional questions, and I think it continues to be, when is an executive agency essentially making up the law on its own, which is basically the essence of legislating, which is essentially something that only belongs to the legislative branch? And when are they simply trying to carry out and administer what the legislature has done with the guidance from the legislature, so that they're basically filling in gaps in trying to faithfully do what the legislature has required. So it's a very difficult decision to try to determine when the administrative agencies of government have gone beyond their role of interpreting what the legislature has given to them, and when they begin to embark upon actually making up the law on their own. But judges do have an obligation to try to make sure that they don't go too far.
You may not want to answer this, but I'm going to ask it anyway. Was the rule of law, can you give me an opinion, applied properly last week? Because to me, as an ignorant person, they went way out of bounds, and I'm so frustrated because I don't know who to trust anymore. And so the question is, do you feel the rule of law was properly applied last week? Maybe you don't want to answer, but I'm going to ask it.
It's not ladies first.
I think Judge O'Brien has some very thoughtful points she'd like to make on this, and maybe I guess in a nutshell, no, I don't think so. I think that the court, I think the court's decision is going to result in a very substantial expansion of the federal taxation power, particularly the power with regard to direct taxation. And when you consider the fact that there's nothing in the opinion that I think will last beyond last week in terms of the scope of the Commerce Clause, because it's all dictum. Dictum is simply when a court says something that it doesn't need to say. When a court expresses dictum and says something it doesn't need to say, what it said, Chief Justice Roberts was really the only one who said it concerning the Commerce Clause, it has no precedential impact. So the only precedential impact, or the principal precedential impact of that decision in terms of federal power will be what I believe is a huge expansion in the scope of the taxation power of the national government. And I think it was an opportunity for the court to have spoken clearly and straightforwardly on one of the great constitutional controversies of our time, the relationship between the states and the federal government, and the relationship between the individual and the state. And in my judgment, it didn't do that.
I agree with what was said. I was disappointed when I read the opinion. I felt as though the majority started with a conclusion and then tried to come up with the rationalization for it. I thought the dissent was very well written. I agree with the dissent. Unfortunately, I don't think the rule of law was followed. I was surprised by the Chief Justice and his interpretation of what is a tax and what's a penalty. I don't think he followed the rule of law.
This is addressed to Justice Markey. From what I understand, or from my understanding, that Michigan is a sovereignty within a sovereignty. And it has its own constitution, its own government and laws. So I'm kind of confused. Am I a citizen of the state of Michigan, or am I a U.S. citizen?
Under the 14th Amendment to our Constitution, you're a citizen both of the state and of the United States. And Michigan has sovereignty, and the state, and every state has sovereignty within the scope of those things that states have sovereignty over. This is clear in the 10th Amendment, I believe. The federal government and the national government is sovereign in some areas, and the states are sovereign in some areas. And to follow up on my answer to the last question, I think that the realm of state sovereignty has been sharply diminished over the past several judicial generations, and the scope of federal sovereignty has greatly been expanded. And I think there was a lost opportunity, as I said last week, to try to rectify this imbalance, because I think one of the great achievements of our American constitutional architecture has been our system of federalism, in which we have a strong central government in those areas in which you need a strong central government, in particular the need to provide national defense and the ability to conduct a coherent foreign policy. But in a good many other areas, you require a strong state sovereignty so that the dictates of the 10th Amendment can be respected, and the diversity, the genuine diversity of the 50 states can be honored, and the people of those states can carry out their desires in the context of a government that's considerably closer to them than is our national government. So, in short, and it's a complex issue, but in short, you are a citizen of both Michigan and the United States, and each of these sovereigns is within their own constitutional realm of responsibility sovereign.
Do we have any last question? Over there. Liz, can you get that one? And then I think as we do that, we'll wrap up. We'll offer you an opportunity if you have any other statements you want to make, and then we'll conclude the program.
If I can be coherent, I don't know if you can answer this either, but I'm really concerned about healthcare in general and parent rights versus state rights and federal government rights and the right to choose for their children. Where do we stand in Michigan? Because I know in Wisconsin they've kind of ruled that the doctors have the right for some of the care of some of the cancer patients, that they have to follow traditional medicine versus natural medicine. And I don't know if anything like that has ever come up in the court and in the Supreme Court, if there's ever been anything like that. If you have the right to choose what kind of health care you want, or do you have to go by state health care?
Well, we have quite a few cases dealing with health care. We have many laws dealing with health care. It's become quite complicated on the state level, just as it has on the national level. Again, we're not responsible in the court for developing these policies. The legislature spends considerable time, just as the Congress spent time in crafting Obamacare. But I'm not completely sure I follow your question.
Well, in the state of Michigan, so our legislature has the laws that they've made so far that they have to follow from the federal government. Do the individuals still have the right to choose their care over what the doctor mandates for their children or even for themselves?
I'm not sure I could answer that. I mean, as a member of the healthcare profession yourself, you're probably more knowledgeable than I am about, how patients actually interact with that system. I just don't know that I could answer that question better than you can. Have people's right to choice, have those been limited in our system?
Well, they have in some states, like the parents can't choose whether to vaccinate their kids or not. It's being mandated, yes, they have to vaccinate. So that hasn't happened in Michigan yet. I don't know if that's going to change under the new Obamacare stuff. Being an medicine practitioner.
Again, I just don't know. I know the healthcare bill is how many thousand pages, and seems like every day we're discovering new provisions that we didn't know about yesterday, and certain new provisions that the members of Congress who voted for it and against it were probably largely oblivious to. But I don't know. I've never seen a case dealing with any right to be or to not be vaccinated. I don't know if there's anything of that sort.
Cancer treatment for children, like the boy that
these would be better addressed to members of the legislature.
Okay, I'd like to offer both an opportunity for any last closing statement, and then we'll go ahead and conclude the program. Okay, sorry.
Well, thank you for coming. I'm sorry, we do have one more. And my question is, where do you see most of your cases coming from? Is it from the state government? It's from local counties? And do they come to you because they're not following the rule of law? In other words, if we could pinpoint these, we as a Tea Party would know where to look, where to work on issues to get people in before they get to you. So is there one area that you see, one group of counties, or is it state that you hear?
Half of our cases are criminal cases, and those are overwhelmingly filed in our court by the defendant himself or herself. And that's simply because, as you know, under our Constitution's double jeopardy provision, once a defendant has been acquitted of a crime, he or she can't be re-prosecuted. So almost all of our appeals come not from the prosecutor, but from the criminal defendant himself, and that represents about half of all the appeals that we get on the court. I'd say another 40% of our cases are just what I call traditional civil cases. And a civil case is simply where you have no criminality, but there's just a dispute between people. Two employers, an employee and an employer, or two neighbors, or an individual in a government. All these kinds of disputes and disagreements may arise and be included in that 40%. In the other 10% of cases, we're basically talking about constitutional cases in which the court's attempting to resolve a dispute by interpreting some provision of the Constitution. And as you probably know, justices of your Michigan Supreme Court take an oath of office to two constitutions. They take an oath of office to the national constitution. All judges around the country do that. And we also take an oath of office to the state constitution. So I'd say about 10% of our cases have to do with resolving a dispute by interpreting the Constitution. In some areas, we see recurrent differences of opinion and disputes, and those will sometimes be called to the attention of the legislature, and if they choose to do so, they can address those so that those disputes are resolved differently in the future. But by and large, we don't speak to the legislature except through our opinions. So when we see problem areas, we may identify those problem areas in our opinions, but we're not engaged in a conversation with the legislature by and large. I mean, by and large, we respect the judgments and the decisions and the work of the legislature, and we hope they respect the judgments and the decisions of the court. And when we see a problem area, we may mention it in our opinion, but we would never insist that they adopt anything, or we would never certainly adopt it on our own. And there are some courts that would, in fact, do the latter.
Thank you. Good answer.
Okay, both of you, if you'd like to make a quick closing statement, and we'll wrap up in just a minute and follow.
I just want to say thank you very much for this opportunity to speak to you tonight. I appreciate you being here. I admire the fact that you are all here and involved and interested in your government. I think that you all realize what an important role the judiciary plays. Unfortunately, most people do not. So I would ask you all to please talk to your friends and neighbors and make sure that in August and then again in November, they vote at the polls for judges, and remember the nonpartisan ballot. So many people, they'll vote Democrat or Republican, and they'll forget to go to the nonpartisan portion of the ballot and really it is just as important as you know, as the other portion. So thank you very much. If you have any questions for me afterward, I'll be here. I also have some literature which has my website with the website address, which you can take a look at, which has further information about my background and endorsements. Thank you very much.
You know, in Michigan, as in most states, we only place lawyers on the court. And that's not because lawyers know how to organize society better than do dentists or tool and die workers. And that's not because lawyers have a more heightened sense of right and wrong than do salesmen or accountants. And it's not because lawyers are inherently more fair-minded than our teachers or doctors. But it's because lawyers alone have been trained to read the law. And I believe that when lawyers put on black robes and become judges, they also have to limit themselves to reading the law as opposed to seeing themselves as having the responsibility of organizing society. When they do that, we the people invariably lose their sovereignty and lose their authority to determine the direction of their society. Over the course of the next 4 months, we are going to be campaigning, and Justice Zahra, who again I know is sorry that he wasn't here tonight, and I are going to be campaigning very hard, and I'm quite sure that we are going to, you know, there's rarely a debate in these campaigns. I've run twice before, and I generally try to participate in this debate and identify, you know, what it is that distinguishes us from our opponents. It's not my surname that distinguishes me or my gender that distinguishes me, but it's the fact that I have a different sense of judicial values that I try to bring to bear in my decisions. And Justice Zahra feels the same way, and we try to communicate this in the course of the debate. But our opponents never debate. Our opponents aren't interested in this debate. Instead, what we get every 2 years are the suggestions that somehow, because our decisions don't produce the kinds of results that our opponents would like, we're corrupt, or we're beholden to the special interests, or we're in the pockets of this group or that group. And I hope as that debate emerges, and it almost certainly will, because it does every 2 years, that those of you in this room who are really among those who reintroduced the Constitution as something important to our society, will speak to your friends and your neighbors and and people you know, and let them know what's at stake. Because, you know, when you look at what happens in the ballot every 2 years in these judicial races, about 30%, nearly a third of all the people who go to the polls don't vote for the judges because they don't know enough about them. And some of those people vote for the judges, vote exclusively on the basis of such things as surnames and gender. And we need you to be among the leadership in this state in communicating to those you know what the stakes are. Because the stakes are considerable. And they're not only considerable for the integrity of your court, but they're considerable for the integrity of all 3 branches of your government. When I told you earlier how many of the reforms of the legislature and the governor have been sustained by a 4-3 vote, I'm talking about how close the legislature and the governor were to not having any impact on the public policy of this state and having the public policy of your state determined almost exclusively by lawyers in black robes. Is that the kind of system we want in Michigan, or do we want a system in Michigan in which the people get to determine their destiny and their future? And our constitutional architecture has always been one in which judges played an important role, and I'm very proud of the role that we play as judges in this state, but we're not the ones who get to make all the important decisions. And what we have in our state, what we've always had in our state, and what we've always had under our Constitution is respect for the great heritage of the rule of law and not the rule of judges. Thank you for what I know you all do.
legislation is dissolved, just one quick comment to remark that Justice Markey made about our legislature working so hard on our health care. Wouldn't it be nice and wouldn't it be appropriate if it was their health care as well?
Thank you all for coming again this evening. I think we can all agree that we're going to be walking out the door with a lot more knowledge.